Good day and welcome to another episode in our series of Lunch and Learn. Today we will be discussing how to prepare for a Section 6 maintenance inquiry. And joining me in studio today is Kara Opperman. She is a candidate attorney at Opperman's Incorporated, a legal firm specializing exclusively maintenance matters, domestic violence and family court matters. Kara, welcome and thanks for joining us.
Hi, thank you, Eugene. I appreciate the introduction and just want to say hello to everybody who's live at home or watching from the website, and just want to say thank you for joining. So yes, today I will be the guest speaker on this topic, and I just want to say that this presentation will largely be based off of the handout, which was made available to those people who registered for the webinars. So it would, just a suggestion, I think it will be helpful to have the handout material open in front of you, just to be able to follow and to see how far we are in the webinar and just the context.
Thank you for that, Kara. Thank you. Sorry for chipping in. I just want to briefly go over what could we expect from today's webinar, so that what you have to talk about today, at least. So today we will be discussing how to prepare for the Section 6 inquiry, to give you an explanation of how the process works, what documents you need, what type of questions you might be asked in court. And Kara will be addressing the role of the maintenance clerks, the maintenance officer, as well as the maintenance investigators, and just give you a brief overview of what is the Section 6, the informal maintenance inquiry held at the maintenance officer's office. So the structure of today's webinar would be, if you have registered, you would have received a link, like Kara mentioned. You would receive a link with the details of the live webinar, but on that you would also find a couple of tabs on the screen. One of the tabs would read pre-reading material. There you would find all the pre-reading material that you can read in your own leisure. That is just history on what is being said and what is being discussed. So it might be a good idea just to give you some context on the subject today. So please have a read through that. Obviously, we'll also have the link to the live webinar that you're watching now, and then the resource and templates tab. Now, under that tab, you would find all the documents referred to. You would find a copy of the slides together with a handout, together with an ebook that we might discuss later on as well. So on that tab, there is valuable information that you need. And we suggest, like Kara said, that you print that out, keep that in a folder. If you intend joining for the next 52 or 51 weeks on the Lunch and Learn webinars, I suggest that you get a couple of archive files, because you would have at least 3 files necessary already to compile all the documents. But without further ado, I'm going to hand over to Kara, that will explain to us how to prepare for a Section 6 maintenance inquiry. Kara, over to you.
Thank you. I'm just so excited to get to the work. So just to give you guys an idea of what this topic is about, I want to talk to you about what is the Section 6 inquiry. And on the slides, you will see that there is a definition, and it can largely be defined as an informal inquiry by a maintenance officer before potential trial. And it's usually done upon the issue and lodgement of maintenance complaints. And on the slide, you can also see that these complaints are, for example, where somebody liable to pay maintenance fails to do so, or where there is good cause for the substitution or discharge of either an existing maintenance order or of an oral or written agreement where there is no existing maintenance order in place. And then just what you can expect on the day. Upon the lodgement of these complaints, the Section 6 inquiry will be done. And since it is informal, it won't be done in court. It's done by a maintenance officer in their office, and they will conduct the session with both parties, and will speak to both parties to assess the documents that they bring forward. And here, each party has the opportunity to present their side and to show the documents that they've brought in an attempt to resolve the matter. And that is ultimately what the Section 6 inquiry is about. The maintenance officer will scrutinize the documents and will try to have the parties reach an agreement. And the maintenance investigator also plays a role in this context, but that will be elaborated a little bit later in the webinar. And then if the parties can ultimately agree on an amount or on a resolution to the complaint that was lodged, then that will be set out in a consent form, which will be made an order of court. And then that agreement will be legally enforceable. And if no agreement is reached, or if there are still outstanding disputes, then the matter can be referred to court for what you would call a Section 10 inquiry, which is not informal, and it will be done in front of a magistrate. But then, yeah, that's just what the inquiry is. But just to give you some practical tips on things that can really help you to prepare before you go to the maintenance officer for this, would be things. So I also always regard the point of departure as maintenance as not being 50-50, because there's no set formula or no set amount that you can claim if your expenses are this or this or this. It's always determined with reference to the reasonable needs of the child, and also the reasonable financial capacity of the parents. It will never be just 50-50 or what mom wants and what dad can afford. It's never like that. And I think it's very important to manage those expectations, because the court will not entertain a maintenance dispute or complaint if it's not a realistic claim. And then secondly, you must know which documents you need to take to court to apply for maintenance, to apply for an increase or decrease, or whatever the complaint is about. There are many websites where you can find the list of documents that you need, even on justice.gov or on childmaintenance.org.za. It's very helpful just to know you have all of your documents ready and to be able to tick all of that off. And then also, it can also help you to file a supporting or a founding affidavit alongside the documents that you lodge, because that will help to set out your case a lot more, and it will actually support your claim in that sense. So that's also a tip that will also help your case. And then another thing which a lot of people actually don't know is that you can include, if it is your first time application, you can include lying expenses into your claim. And lying expenses can be defined as the reasonable costs that have been incurred by a mother during her pregnancy and directly after birth. So that basically means and a lot of people don't know this, in your initial application for maintenance, you can also include these costs that range from the date of the child's birth to the date of the inquiry. And that will just add to your claim. But then also other things you can include would be, for example, future maintenance, if that's possible, such as pension or retirement annuities. And it will also help if the affidavit just includes or takes cognizance of any oral or written agreements between the parties as to the dispute. And then the third point, or the third practical tip I want to give would be just regarding the financial information, which the parties present to the maintenance officer, because the expenditure that you fill in your application for maintenance form, which is the J101, those expenses will be used largely as evidence in the Section 6 inquiry. And that's why it's extremely important to make sure that that information is correct, that it's not misleading, that it's reasonable, and that it's up to date. But then on the other hand, there has to be a fine balance between correct and sufficient information to be able to sketch a full idea of the facts, but then also overburdening the maintenance officer with unnecessary documentation. And that's why I want to stress that the information must be concise and it must be relevant to just make sure that we don't waste time, but also the more you include, the more of a well-rounded idea will be sketched of your financial position. And then just to continue on the rest of the practical tips, the next one is to be open to agreement, to be amicable to finding a resolution, because that is the point of the Section 6 inquiry in the first place. And since it will be done in an informal manner at the maintenance officer's office, the parties will be sitting close to each other, they will be seeing each other, and for a lot of the parties, they maybe haven't spoken to each other in a long time, and this is the first time. So it's important to know beforehand that you will be placed in that scenario, and that, yeah, the aim is for everybody to find a solution to the dispute. And it will only help to respect this informal process, because ultimately it is done to be able to ensure the best interests of the children that you know are part of the child maintenance dispute. So be open to agreement. And then also, since the Section 6 inquiry is one of the first big steps that you take in addressing a maintenance complaint or applying for maintenance, there's also always the chance that paternity disputes will come up, and it's also largely used as a delaying tactic, which parties must be aware of, and they must stand strong for their children. But they must also know that these disputes can ultimately delay the process, of course, but it can also increase emotions, and it can increase costs for the actual testing. But just being prepared and knowing that that's a possibility is already helpful. And then lastly, as to the practical tips, it will always help to know and understand your rights and responsibilities. And I think everybody watching this webinar is doing that right now, is empowering themselves and is learning about what they must do and what rights they have. And I think it'll just ultimately guard against surprises. It's like managing expectations and just knowing you have rights, but also that you do have responsibilities. And I just want to highlight a few rights, which would be the right to appeal. You can also always appeal any decision by a maintenance officer or a maintenance court. And that's a right that we have. But also the right to use civil remedies where the dispute doesn't go anywhere, such as in Section 26 of the Maintenance Act, there are three main enforcement mechanisms of maintenance, such as execution against property, the attachment of emoluments or a garnish order, and the attachment of debt. And you have a right to use those remedies in appropriate circumstances. But then just as important, if not more important, are the responsibilities, which will include that a party must know that they must give information, and they must let the court know if there was any change in address, in their residential address, and also that a party must know that it is an offense not to pay maintenance, and it can be a criminal offense in Section 31 of the Maintenance Act. But then also, lastly, a responsibility would be that a party to a maintenance dispute must know that their arrear payments can be listed on credit bureaus, which can affect their creditworthiness as such. And these are ultimately just things I find helpful to know before even going to court. But then other more broad considerations, but also just to keep in mind that a party approaching court can also approach to the court or the maintenance officer to vary an existing agreement. And that's also just to bring it back to the relevant complaint, what the substitution and discharge refers to when somebody applies to either have their existing maintenance order increased or decreased. And that's also a possibility in a Section 6 inquiry, which you can know about beforehand. And then I want to get to the relevant people in this whole process that have a set roles and functions in the Section 6 inquiry. So firstly, I want to talk about, and basically this will be in the order that you actually come across these people, and on the first attempt, or the first interaction at the court, you will talk to a maintenance clerk who will, as you can see on the slide, receive and capture your documentation to transfer it to the maintenance officer. And yes, they are the first person that the applicant comes across, as they will be sitting there and greeting you and taking your complaint for the most part and hearing it for the first time. And that's why education to these maintenance clerks is so important, because maintenance matters are quite often sensitive, and that's why a maintenance clerk dealing with a first-time applicant who is very confused about the process and scared and nervous, they must act with the necessary respect and just care and skill to handle such a person in an emotionally vulnerable state. And I just want to stress that, because I think it's important, even though they just have the job of receiving all of the documentation and gathering everything to have it ready for the Section 6 inquiry, they also have the responsibility to treat applicants with care when they approach the court for the first time. So that's largely a maintenance clerk's job. And then to go to the maintenance officer, and as we've spoken quite largely about the maintenance officer, they obviously conduct the Section 6 inquiry in their office to investigate the relevant complaints. And then I just want to read to you what they have a whole list of powers under Section 7.2 of the Maintenance Act. And these powers are so crucial, because it really does show the powers that they have in the Section 6 inquiry to be able to get the parties to see each other's side and to actually try to resolve the dispute. So functions of a maintenance officer would be, for example, to obtain statements and or relevant information under oath or affirmation, which is very important. They can also gather information about the identification, whereabouts, or financial position of any other people that concern the maintenance complaint. They may also request a maintenance officer in another jurisdiction to exercise their functions in the same manner, to have the courts correspond with each other on maintenance applications or maintenance complaints that take place in different jurisdictions, which is very helpful. And then also they can require a maintenance investigator to act as necessary. And that is a very, very important job as well. But ultimately, a maintenance officer has the job to conduct a comprehensive Section 6 inquiry. And they basically have the opportunity to sketch a full idea of what the parties are asking and what their means are, what the financial position is, and in an attempt to reach a reasonable conclusion that both parties can agree to. Now, the maintenance officer does this by conducting a lot of calculations and ensuring that what is being claimed is reasonable compared to what is actually possible. And that's a hard job. But then also, if the parties obviously reach an agreement, that will be made in order of court. But if they don't, it can either be sent to court for a Section 10 inquiry in front of a magistrate, or a maintenance officer can also, if the parties don't reach an agreement, the maintenance officer can recommend an amount based on the pro rata apportionment of the parties' financial means, based on Section 15.3 of the Maintenance Act. And yes, that is the maintenance officer. But then, as you can tell, they have a lot of jobs. And that's why the next role player, the maintenance investigator, is also very important. And there you can see again all of the functions listed of the maintenance investigator, because the main aim of the introduction of this role player in the maintenance process was, as far as I understand, to lighten the administrative burden that the maintenance officers have with the amount of information and documentation that they are thrown with, and then having to kind of decide on that and try to understand the financial positions of the parties in an attempt to reach a dispute. So that's why the functions of the maintenance investigator is so important, because they almost have the same functions as a court in some instances, or court officers such as a sheriff. And you can just see on the slide there that they have functions such as locating the whereabouts of persons who are alleged to have failed to comply with the maintenance order, and they can serve or execute the processes of any court, and they can also service documents such as a sheriff, and take statements under oath or affirmation from persons who are relevant. And yeah, they can also, similarly as the maintenance officer, gather information about the identification, whereabouts, financial position, etc. of any other person or relevant fact to the complaint. And yeah, they are very helpful. And I think on the next slide, yes, it sets out nicely what assistance this role player will give to the applicant, because ultimately what it boils down to is the fact that a maintenance investigator will ensure the efficacy of the entire process. They will make sure that the parties are actually found, actually tracked down, and that the documents are actually served on them where it's outside of the capacity of the maintenance officer to ensure those things. So they, once again, ultimately share in the burden placed on the maintenance officer, and especially when the maintenance officer doesn't have the necessary resources or means, or even not as wide functions and legally allowed functions and roles that a maintenance investigator has. So that does really help with the efficiency of investigating complaints. And then just to give you an overview of the types of questions that can be asked. Now, I mean, we've spoken about all of the practical tips about what the inquiry is and all of the role players, but now just to actually bring it back to real life questions that will be asked. So you can see there's a nice illustration of the entire process, which once again, it starts with the complaint that is received by number 2, the clerk of the court, and then all of those documents are captured and received by the maintenance officer, who will then scrutinize the documents at a Section 6 informal inquiry. And then only if the parties do not reach an agreement will the matter be referred to a Section 10 inquiry in court or in front of a magistrate. But then these are just a few, as you can see, with regards to the respective phases of the inquiry. Here you can see the documents, the questions that you might be asked, and it will definitely help you to prepare answers to these questions and to ensure that you know which questions might come up to just guard against any unexpected questioning. But for example, the clerk of the court will ask you whether you have all of your documents ready, whether you have your ID, the address, birth certificates, whether you filled out the J101, which is the point of departure in maintenance applications, but then also proof of your income and expenses. And then on the next phase, the maintenance officer will similarly ask questions like those, but it will be a little bit more focused on reaching a conclusion between the parties. So, for example, questions will be like, how much maintenance is needed for the children, and that's where a calculation will have to be done to determine what is reasonable and what is not. And the maintenance officer can also, for example, ask the parties what their income is, what their expenses is, and whether they have all of their documents in order, which is very, very crucial. And then at the Section 6 inquiry, the similar questions, as mentioned under the previous slide, that the maintenance officer will ask, will most likely be asked at a Section 6 inquiry. But the difference is just because it is an informal process that is legally prescribed, a discussion of the rights of parents will have to be included, and parties will also have to be informed of their different rights and responsibilities. And a confirmation of paternity will also be done at the Section 6 inquiry, which is why we previously spoke about why applicants should rather be prepared for a potential paternity dispute during the Section 6 inquiry. And then at court, this will be a lot more elaborated in following webinars. But in court, what will happen if the Section 6 inquiry isn't successful? The matter will be heard in front of a maintenance magistrate, and they will ask questions, for example, how much is needed for maintenance for the children? I mean, basically the same as in the Section 6 inquiry, but it's definitely a lot different, as it's not an informal process. It will be done in court, which means that the rules of evidence have to be followed, and court processes also have the possibility of cross-examination, which might be quite tricky in a sensitive maintenance matter. And I think we can definitely speak about that. I think Mr. Eugene Opperman can also elaborate on the impact a potential cross-examination can have on a maintenance applicant, and just how how unnerving that must be. But then, yeah, I want to also just give you another broad overview so that you can see all of the different phases again in the Section 6 inquiry from the complaint straight through to all of the different role players, the informal inquiry, and then what happens if a dispute is reached or not. And then, yes, now it's time to discuss a few questions, and we will have a bit more of an interactive session now.
Brilliant. Thank you for that, Garu. It was very enlightening. A couple of points that I would like, as a start-off point with the discussion, that I would like to circle back to is you mentioned the consent form, the J21 form, 214 form, which is a judicial form. And maybe I should just bring that up on screen so that the attendees could see that. If I can just get to that quickly. This is basically what a J214 form looks like. Now, this form could be used not to sidestep the process, but ultimately this is when the parties come together and they reach an agreement. Then a consent form, a consent and maintenance order will be done on a Section 214 form. Which means that it's not necessary to go through the whole court process. Now, I've had clients where one client is in George and the other one is in Klerksdorp, and the father consented to the amount that the mother wanted for maintenance after he read through her application form. So he filled it in George, and then she was in Klerksdorp, and we sent through the consent order completely signed by the father, and the court actually then, based on this, made a court order without him having to appear. So that is just as a sake of clarity for the listeners. I will also, together with the J214, the consent order, it might also be a good idea if the people are remotely interprovincial, that you file a supplementary affidavit or founding affidavit regarding that. And I'll drop that into the resource folder. I'll drop in the copy of the J214 together with the affidavit for the attendees to use. Just another one. Yes, I'm glad you touched on the point of the 50-50 split, because there's a common misperception that maintenance is divided strictly 50-50, and that is not so. It is based on the means of the parties, and so in terms of Section 15, the law is quite clear on that, and we will be discussing that on later webinars or prior webinars. I think we've discussed that as well. Like I said, the founding affidavit that you've mentioned in the Section 6, I will drop a copy thereof in the resource folder for the attendees to look at. It's also always wise to follow up or to include a founding affidavit together with your Section 6 application, the J101 application form. Lying-in expenses, you've mentioned that briefly. That is brilliant. I love that. Also, just bear in mind for the attendees that the lying-in expenses, that is expenses from birth to up until the stage that you claim for maintenance, could only be done once. So you can only claim for that one time only, and that would be on the first application. You cannot claim for lying expenses if you already have a maintenance order that is in place. So you can't come 2 years, 3 years after that. You come and you say, right, you want lying expenses. The court will not entertain that. It can only be done on the first application. When you do your first application, remember to ask for lying expenses. You briefly mentioned, sorry, I'm just rambling off. I made a couple of notes, and you can ask me questions. We still have time. You can think just afterwards. Yes, with regards to the assistance of the clerk of the court that needs to assist you when completing the form. We found that many courts turn the people away because they do not have birth certificates or they do not have ID documents. In terms of the DOJ Code 26 of 2015, that is a code of conduct that the DOJ personnel needs to abide by. It clearly states that no complainant may be turned away because they do not have an ID document. That is very important to note. Also, similarly important there is that the clerk of the court, it's one of the responsibilities of the clerk of the court, in terms of the DOJ Code 26 of 2015, that the clerk of the court must assist the applicant in completing the forms and also render all assistance necessary for that person, for the complainant, in order to proceed with the maintenance. So if you turned away at court, then ask to speak to the court manager and insist, because like you said, know your rights and responsibilities. That's one of your rights. You know what? It is your right to be helped at court by the maintenance clerk. I just want to circle back to the maintenance investigator in terms of Section 7 that you've mentioned. Yes, it is truly so that most courts do have, they employ the maintenance investigators. The problem is that not every court has a maintenance investigator. So you would have 2 or 3 courts sharing a maintenance investigator. And like you said, the maintenance investigator is the sheriff. He is the one taking down affidavits. He's attending to all sorts of things, together with tracing as well. The problem is that I found in practice is that if you do not have the correct information and you rely solely upon the maintenance investigator for assistance, then you will expect delays. It usually takes up to 6-8 months for the maintenance investigator to get to that point where they can actually assist you or attend to your file. Things that the maintenance investigator could do is some of their functions. They could trace a person. If you have his car registration number, the maintenance investigator can do an e-natus trace to trace the whereabouts or the owner of that vehicle. They can do a wind deed trace where they trace immovable property to see, you know what, does the father have any property in his name? They could issue a subpoena to the banks, all the 5 major banks, to ask them for the banking statements of the father. Why I'm saying this is because I also wanted to bring it back, like you said, you talked about the responsibility. There's also responsibility upon the mothers to not come to court empty-handed and expect miracles. It's not going to happen. You will be disappointed. So my advice would be is to come as fully prepared as possible. Bring all the documents. Do your social media searches. Check him out on Facebook to say, okay, right, you know what, he's got a new job. Where does he work? What car does he drive? You know what, they brag on Facebook, you know what, they've got a new car. You know what, zoom in and see if you can't get the registration number, all those things. So there's a responsibility on the mothers, not just to sit back and say, right, you know what, they just throw their hands up in the air. They expect the court to assist. They still have some responsibility on maintenance or to bring the documents to court as well. That's basically it. So you have a couple of questions for me.
Yes. Well, I've been thinking about this for a few days now, whether it's possible to completely skip this crucial, what I would think is a crucial attempt at resolving the dispute in the fastest and cheapest way. Would people be able to skip the Section 6 inquiry, or is it compulsory to try to resolve the dispute before going to court and then following those rules, which would be formal court rules?
Obviously, the Maintenance Act is structured in such a way where you have certain things happening in a certain sequence. And that one would be the Section 6 inquiry, which is solely geared or aimed towards getting all the information ready from the fathers and the mother, from both parties, in order to do a financial inquiry before it moves on to a Section 10 inquiry if the parties cannot resolve the matter in terms of the Section 6 inquiry. So the question, if I understand it correctly, is to ask, you know what, can you bypass this Section 6 inquiry and move directly through to court for a Section 10 inquiry? The answer there would be no. The court is there's a court case, Ilsley versus Lechobo, which was handed down in the South Gauteng High Court in 2012 or 2011, where it clearly stated that the Section 6 inquiry, the investigation of the Section 6 inquiry needs to be completed first in the maintenance officer's office before it could be transferred to court. And we find that in a couple of cases, remember, there's not a lot of maintenance cases going on appeal because obviously the mothers can't pay for it because it's an expensive process. But with the case law that we have at this stage, Ilsley versus Lachopa says very clearly that you have to exhaust first all the avenues in terms of Section 6, the informal inquiry, and then to proceed to the Section 10. And there was a Circular 7 of 2012, Circular number 7 of 2012, that was circulated amongst all the DOJ staff, all the maintenance officers, explaining the case of Ilsley versus Lachopa to them and telling them and just reminding them that it would be irregular not to do a Section 6 inquiry and transfer the matter directly to court. However, like I mentioned just a while ago, you can, without going to court, you can consent. The father can consent in terms, and by completing a J214 form, he can consent to the amount that the mother requires for maintenance. And by that way, you would sidestep the Section 6 inquiry completely, or it might actually, that could be resolved during the Section 6 inquiry, where the father says, you know what, I'm prepared to pay that amount. After some form of mediation has taken place, then the father would say, you know what, I'm happy, I'll pay that amount. And then the maintenance officer would simply complete a J214 document and give that to the magistrate, hand it over to the magistrate. The magistrate would make that an order of court, and there you go. There's no need for you to appear in court.
Mm-hmm. Okay, that makes
Next
sense.
question.
I also felt like the importance of the Section 6 inquiry hasn't been stressed enough, because if you can get your problem solved then and there, why would you even just try to skip it? But thank you. That makes a lot of sense.
Totally agree.
And a lot of clarity.
In terms of the recommendations of the South African Law Reform Commission, which I was party to, or I joined them on their panels as well, they mentioned that there are, with the new proposed amendments to the Maintenance Act, there will be a form of mediation. So it could be either a structured mediation done by the maintenance officer, or it could be a community mediator, or it could be a private mediator that could actually mediate the process of maintenance. How that would be done is still remains to be worked out, all the nitty-gritty regarding that. But there's quite a number of people lobbying for formal mediation to be done as part of the Section 6, which I totally agree with, because that would alleviate the burden from the maintenance officer, unless it is expected from the maintenance officers to actually conduct all these type of mediations, because they simply would not have time to do that.
Yeah. Okay, thank you. That makes sense. And I also want to, while on the topic of maintenance mediation, I want to say that we will also be doing a future webinar which deals with mediation in a maintenance context. But before we get to that, I want to ask my last question. And this is more around the maintenance investigators and how exactly they play a role, and when must a maintenance officer ask for the assistance of an investigator. And if they don't, and the parties are struggling to for example, locate the whereabouts of somebody, or just struggle to get sufficient facts for their case, can a party ask a maintenance officer to acquire the assistance of a maintenance investigator, or can a party even approach a maintenance investigator themselves and ask them to, for example, trace somebody or just help them find facts?
Good question. Very good question. If one looks at the hierarchy of the DOJ, you would find that the maintenance officer is in a higher scale. The maintenance officers, one of the requirements, the training requirements of a maintenance officer is to have a law degree. They need to have an LLB degree in order to conduct maintenance investigations or to act as a maintenance officer. Whereas the maintenance investigators are subsidiary. They are working with the maintenance officers. So to put it bluntly, they're on a lower pay grade than the maintenance officer. So yes, basically the Act is also very clear in terms of Section 7. about the duties of the maintenance officer and the maintenance investigator is that the maintenance investigator cannot act on own accord. They cannot take instructions directly from the complainants. They have to receive their directives and the instructions from the maintenance officer. So my suggestion to the attendees and the listeners out there would be is to if you have, bring to board all the information that you have and explain to the maintenance officer that, I know for a fact he has a separate Capitec account, or he's got a Standard Bank account, or whatever the case might be. Bring that to the attention of the maintenance officer, because they would not know that. And once you tell them that, ask them to please ask the maintenance investigator. Put in a request. Make sure it's been noted on your maintenance file. Ask the maintenance officer to instruct the maintenance investigator to start proceedings to investigate, to see, what bank accounts is there, how much money is in that bank account. So by following that route, you could actually then, via the maintenance officer, request the services of the maintenance investigator. But nothing stops you from using a separate company or a private company doing tracing to get all the information. And then that would obviously fast track your maintenance application quite considerably, because you can go to court and you say, but you know what, I've got a tracing report, this is the address, this is all the details. Then you do not have to wait for that 6 or 8 months for the maintenance investigator to get to your file. Right, I think that brings us to the end of our session today. Much thanks to Karu for joining us today. This was absolutely brilliant. We've done the questions and answers. Yes, that's just many things. Thanks for that. Karu Opperman is an article clerk at Opperman's Incorporated. I'm one of the directors there, or I am the director there. I'm also a qualified practicing attorney, family law attorney and mediator from Opperman's Attorneys, specializing specifically in maintenance matters, domestic violence and children-related matters. Thank you so much for joining. We'll see you next week, same time, same place. Have a good day. Thank you, Karu.
Thank you.